I think it's safe to presume that all of us vividly remember Brown versus Board of Education and battles over desegregation. Brown marked a defining turning point in American life. It was a cataclysmic step in recasting issues of race in American life and culture. I was 12 when Brown was decided in 1954. The civil rights movement over the next 2 decades was constantly in the news as I went through school, college, law school, and thereafter. I think we're all of an age to remember that in Warren's first term as Chief Justice, the Supreme Court unanimously held that state laws mandating racially segregated schools deprived African-American children of the equal protection of the laws under the 14th Amendment. And then the following year, the court ordered the states to eliminate mandatory segregated schools, quote, with all deliberate speed, close quote. It didn't have to happen that way, and it almost didn't. Why did it happen that way? And I think there's a combination of a number of historical events. There's a lot of luck involved, circumstances, and in many ways, a part of the convergence of the right persons at the right time. We'll see where the luck comes in with a change in the court that happened in 1953. But before I go there, I want to start with the context that underlies the Brown case. And it begins almost where the impact of the Dred Scott case that I talked about last week leaves off. Because I believe that to fully appreciate Brown's impact, it's necessary to see how the racial regime it attacked came to be. So we're gonna, if any of you remember Bullwinkle, Rocky and Bullwinkle show, it's Sherman with the Wayback Machine and go back to 1866. The Civil War is over. The 13th Amendment passed and adopted, and the Republican-dominated Congress, with the support of most Northern whites, realized that assertive action was needed to prevent the former Confederacy from virtually re-enslaving the formerly enslaved men, women, and children. So Congress enacted a Civil Rights Act over Andrew Johnson's veto that provided that the former slaves were citizens of the United States entitled to the privileges and immunities of citizens. And it also provided that no state shall deny them equal protection or due process of the laws. Now, the Constitution doesn't define who is or is not a citizen. The Constitution left suffrage who can vote up to the states. It merely provides that whoever is allowed to members of the lowest house of any state legislature can vote for members of the House of Representatives. And by the way, as you recall, when the Constitution was written, that was the only federal office that was filled by election. The senators were selected by state legislatures. The Electoral College picked the president, and the Electoral College was picked by the state legislatures. There were no rules there. As of 1865, every state constitution had a Bill of Rights, but even most of the free states effectively relegated non-whites and women to second-class status by allowing only adult white males to vote. Congressional leaders were concerned that defining citizenship might be held beyond the delegated powers of the national government. Because if you recall, when the Constitution, the powers of the federal government are laid out in Article 1, and the federal government is deemed a government of delegated powers. Theoretically, it was assumed that the states were the primary repositories of the people's sovereignty. And the states and the people were delegating to the federal government certain things that the government can do. And they are enumerated in the Constitution, principally in Article 1, Section 8. But who is a citizen of the United States isn't one of them. So in 1866, Congress submitted the 14th Amendment to the states. It was designed to do a number of things, and it contains 5 separate sections. The last one being that Congress has the power to enforce the previous 4 by appropriate legislation. But what were those 4 sections? First, it was designed to overrule the Dred Scott's holding that Blacks were not citizens. Therefore, it extends citizenship with equality before the law to all persons born or naturalized in the United States, other than Indians, which is a subject for another class. And the first section reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So that's the first section of the 14th Amendment. But what else does it do? First, you might recall that there was a 3/5 rule in the Constitution that in effect gave Southern states additional representation equal to the number of 3/5 of all their slaves. Because even though their slaves had no legal standing in the South, could not vote, were not considered people with any of the rights to contract, right to marry, or anything like the right to own property. So, but in the Constitutional Convention, the compromise was to give them a value of 3/5 for increasing the power of the Southern states. So that's, with the 13th Amendment, that's out. But there was a concern in the North, but now they're all going to be counted on a one-for-one basis. But what if the South continues to deprive them of the rights of citizenship? So the second section of the 14th Amendment says representatives shall be apportioned among the several states according to their numbers, blah, blah, blah. But when the right to vote in any election for the choice of electors for president or vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the state legislature, is denied to any of the male inhabitants of such state, or in any way abridged except for participation in rebellion or other crime, the basis of representation shall be reduced in proportion to the whole number of male citizens that of those that were denied the vote. So the idea is in the 14th Amendment that we're going to try and encourage the Southern states to allow their former slaves to vote. Because if they don't, if they exclude them from the right to vote, then we're going to reduce their representation in the federal government. The third provision was that it said that any person who held office in the South, either as a state, in any state that succeeded, or in the Confederate States, would be ineligible to hold any federal office unless Congress, not the president, gave them a pass. And the fourth provision of the 14th Amendment provided that only the union debt money, only obligations of the union and states to support the union cause had the force of law. But all the money that was borrowed, all the notes, all the bonds, et cetera, that were used to finance the Confederate side would be unenforceable. And only Union soldiers would be entitled to pensions. So that's the 14th Amendment. John Bingham of Ohio, and I'm going to switch here. Let me just do something real quick because I do have slides. Slideshow. Oh no, I got to do, okay, slideshow. Slideshow. Play from the start. Okay, now I got to figure out. How do I?
Sir, can we ask you a question?
Yeah, I got to figure out how do I share screen when I've got the slide up. I guess I got to get out of this.
Gotta get out of that.
Yeah, and then go to share screen, which is right here. No, that's not it. Where is my picture? There it is. Okay, so I do share screen. Okay, desktop. Share.
Good.
Now I go to slideshow and slideshow, play from start, and go to the next slide. Okay, Someone was going to ask a question.
Yeah, this is Ron Seckel. I wanted
Yeah,
to
hi,
ask
Ron.
you. Hi. On amendment number 14, you said there are 4 things, and I understood number 1, but can you simplify what number 2 and 3 were?
Yeah, number two merely says that to encourage allowing former states to vote, that representation in the federal government, in Congress and in the Electoral College, the representation of the former Confederate states in Congress, there's a fly in my face, would be reduced proportionally to the number of citizens who are not allowed to vote in the South. So if a southern state only allowed whites to vote and a third of the population were blacks, then they would lose a third of their representation in Congress. Their representation would only be provided based on the number of voters as opposed to the number of persons.
Ah, okay.
Because they wanted to encourage southern states to have people vote. That was the second provision. The third provision merely said that if you've been the governor or you've been a member of the state legislature in the former Confederacy, or you've been a member of the Confederate government, and then you were not allowed to hold any federal office unless Congress gave you a pass.
Got it.
Okay. John Bingham of Ohio was chairman of the House Judiciary Committee, and he wrote the second sentence of the first and second sentence of the 14th Amendment. Bingham stated that he intended that this language would make the Bill of Rights binding on the states. In 1833, the Supreme Court, in a case called Barron versus Baltimore, had held that the Bill of Rights only applied to the federal government. Notwithstanding Bingham's view of Congress's intent in adopting the 14th Amendment, the Supreme Court didn't hold that the Bill of Rights protections applied to state and local governments for some times, and then did so only incrementally. And that's going to be what I'm going to talk about in connection with the Second Amendment next time. You're going to get the history of how that happened. During post-Civil War Reconstruction, let me just stop share. Okay. During post-Civil War Reconstruction, Congress passed a number of laws attempting to protect the rights of former slaves. Various Civil Rights Act made it a crime to deprive anyone of constitutionally protected rights by intimidation or violence. Laws prohibited official discrimination and public accommodations. Laws established private right of actions for alleged deprivation of rights. And Congress passed a Reconstruction Act that divided the South into separate military districts and then conditioned seating members from those states in Congress on the states basically allowing African Americans to vote, adopting state constitutions that reflected the end of slavery, and ratified the 14th Amendment. And by the way, that's how states are recognized. The Confederate states were recognized as back in the Union. They effectively weren't back in the Union until they were allowed to have representatives in Congress. And that didn't, and Congress during Reconstruction conditioned that on certain requirements. And then Congress proposed and the states ratified the 15th Amendment, which guaranteed adult male suffrage regardless of race. But by the early 1870s, it was becoming increasingly obvious that practical enforcement of civil rights in the former Confederacy was possible only by compulsion, including continued occupation of the South by federal troops. And it was becoming equally obvious that the political will in the North to do so was evaporating. A series of cases decided during the 1870s, 80s, and 90s brought this home. First was a case called the Slaughterhouse Cases. That's the name of it, the Slaughterhouse Cases. It was decided in 1873. The facts of that case had nothing to do with race, but it was a fight over the power of Reconstruction government provisions in New Orleans during Reconstruction. the city, Louisiana, its Reconstruction government passed a law that required all butcher shops, all people engaging in the business of being butchers, had to conduct their business in one location. They, in effect, built a centralized slaughterhouse because what they were trying to do was eliminate this idea of everybody could slaughter animals in their backyards and put the crud in the river, et cetera. It was passed as a public health measure. But the white butchers objected. They said that this is interfering with our right to conduct business. It's a violation of our constitutional right to conduct business as we see fit. It deprives us of property, mainly the right to conduct business where we want, under the 14th Amendment. The majority of the court had absolutely no problem dealing with this case. It held that it was a legitimate public health measure that was no different from any other public health measure, of which there were many that the court had approved, and that the 14th Amendment was, quote, designed to assure the freedom of former slaves, not to transfer the security and protection of all civil rights from the states to the federal government. And this was the pre-Civil War understanding. Civil rights were to be protected by the states. And the Supreme Court believed that this changed outside the context of eliminating slavery, that this did not change. Now, there's a dissent in this case that later becomes important because Justice Stephen Field, who was a Californian, felt that the 14th Amendment's right to due process had a substantive effect. It didn't just go to procedural fairness, but it actually had a substantive effect that if a state law deprived a person of a property right without compensation, that constituted a violation of due process, and that any interference with property laws that was deemed unreasonable violated that test. That's called substantive due process. And that actually becomes very relevant later on. And by the way, it was decried extensively it was adopted by the court and then lambasted by Justice Holmes, who once said that the court has no right to ingrain Herbert Spencer's doctrines in the Constitution. And we'll see when we talk about marriage equality that the idea of this reading of due process actually is behind marriage equality. Okay, so that's in effect, that was the first case that held that the 14th Amendment did not transfer the security and protection of civil rights from the states to the federal government. The next case that's important in this is U.S. versus Cruikshank, decided in 1876. White Louisianans, supported by the Klan, actively opposed Reconstruction, especially state and local governments that were dominated by Northern Republicans who were called carpetbaggers, who'd come during and after the war, and African Americans. Elections were hotly contested, with both sides claiming that any win by the others was due to either ballot fraud by Republicans or violent intimidation of Black voters by Democrats. In Colfax, Louisiana, let me share the screen here. In Colfax, Louisiana, a crowd of hundreds of local Blacks and their white Republican supporters assembled around the local courthouse to protect Republican officials who were inside. They were attacked by a militia, or a mob, if you want to call them that, of armed whites. In the bloody confrontation, 3 whites and over 200 Blacks were killed, about 50 of the Blacks allegedly after they'd surrendered. But during the 1920s, and by the way, on the upper left-hand corner of the slide, you see how this was described in the national press at the time. The Colfax Massacre, first reports fully confirmed, nearly 200 colored men killed, outnumbered and shot down without mercy. But in 1920, monuments were erected to commemorate the end of carpetbag misrule. So look at the signs that were put up in 1920. A state marker, the one on the lower left, said on this site occurred the Colfax riot in which 3 white men and 150 Negroes were slain. This event on April 13th, 1873 marked the end of carpetbag misrule in the South. And then in 1920, they erected a monument, a stele, you know, a column that was erected to the memory of the heroes of Stephen Decatur Parish, and it names the 3 whites who fell in the Colfax Rising, fighting for white supremacy.
You know if that's still there?
No, I don't. I've never gone there, and I don't know if it's still there, but I would think that by now it would be gone. I would hope it would be gone. Several of the militia leaders were tried and convicted of forcefully violating the Black citizens' civil rights. All 9 justices agreed to overturn the convictions. A minority of 4 held that the language in the law was too ambiguous to support a criminal offense. But the other 5, the majority opinion, held that the 14th Amendment did not incorporate the Bill of Rights, and the amendment's due process and equal protection clauses only spoke to state action, not to state inaction. In other words, the 14th Amendment said that states cannot do something affirmatively. It doesn't say that the state must make sure that nobody else does this. Under the Constitution's federal system, protection of citizens' rights against non-state action was a matter of state, not federal law. And interestingly, the 5 justices who were in the majority in this case had all been appointed by either Lincoln or Grant. Measures came to a head in the 1876 presidential election. Before Bush versus Gore, this was the most contested election in American history. Democrat Samuel Tilden, the governor of New York, carried the popular vote over Republican Rutherford B. Hayes, but the Electoral College vote was split, with the outcome dependent on resolving 19 contested votes from 3 southern states where Republicans claimed that whites had forcefully prevented counting votes from majority Black precincts. Congress was divided. The House led by Democrats and the Senate was led by Republicans, and neither side would give in. So they agreed to appoint a commission consisting of 7 Supreme Court justices. 3 would be selected by Democrats and 3 would be selected by Republicans. And those 6 would pick the 7th, Justice Davis, who was known to be an independent. So they figured this was the fairest way. But Justice Davis resigned before the commission could meet. Unfortunately, the Democratic Party in his home state of Illinois knew that he wanted to be a senator. And so the Democrats in the Illinois state legislature elected him to the Senate. And he resigned his seat on the court to become a senator. So that's a rule, be careful of what you do, that there's unintended consequences. Needless to say, there was only one other justice left that could be nominated to fill the slot, and he was a Republican, and the votes were awarded to Hayes. Now, Southern Democrats seemed ready for war again, and the Democratic House, the part of the Congress that was controlled by Democrats, refused to certify the election. But finally, a deal was made literally within a week before inauguration. Hayes got the gig, and he agreed not to seek re-election. Secondly, he agreed to appoint Democrats to head the post office and the Treasury Department. These were the principal sources of federal jobs, and so it made sure that the Democrats got the jobs that they wanted, because they've been frozen out for a long time. And third, and most importantly, Hayes agreed that the first thing he would do would be withdraw federal troops from the former Confederacy. Now, the end of Reconstruction in 1877 reflected how most of the country felt. Most Northerners desperately wanted a return to some kind of normalcy. The liberalism of Northern reformers who had led the antebellum effort to end slavery and advance the cause of free labor had shifted. They now embraced a pro-business laissez-faire elitism in what was called the social gospel of wealth. Now, the Republican ideal of free labor envisioned that former slaves would embrace a work ethic entrepreneurialism. But that's not what happened after emancipation. Former slaves resisted the regimentation of wage work on white-owned plantations. They wanted to control their own and their own family's labor. And because they had been prevented from enjoying so many things, their life had been so regimented, frequently for the former slaves reveled in their freedom to basically enjoy life. And so what they ended up doing, deciding, and the compromise, and at the same time, Southern plantations, although the Southerners continued to own their land, they now needed labor. And so the compromise of sharecropping was worked out. But in these same times, during these post-Civil War years, Northern labor responded to the massive industrialization by seeking shorter work hours, days and weeks, and engaging in strikes. Consequently, by the end of the 1870s, there just wasn't the political will to continue pouring resources into protecting Black civil rights. With Hayes' inauguration in 1877, the former slave states were allowed to work out their own solutions to race relations that were predicated on white supremacy. And the Supreme Court went along. And I just want you to compare two of Thomas Nast's drawings. Thomas Nast was the American who really invented modern, there's a fly that's circling around here and I'm trying to get it. He literally invented the modern political cartoon, the use of a single image to convey complex ideas about, on political issues. And if you look at a cartoon he drew in late 1865 that supported Black suffrage, and the way the Blacks celebrated Black soldier is pictured, and compare that with his cartoon Colored Rule in a Reconstructed State from March 1864, you can see that the images reflect a fundamental change in changing attitude towards African-American political power.
You
Yeah.
open the window, it might go towards.
Well, the window is open. My wife is saying, and she's noticing my fly. Teachers endure so much. In 1883, I've used these kind of pictures. There's other ones. I could have picked a whole number of them that reflect this change, but I think that these two suffice. In 1883, the court decided in a number of cases that were consolidated as the civil rights cases. And the court held that the 14th Amendment did not give Congress the power to affirmatively impose rules preventing discrimination, that the 14th Amendment only responded to discriminatory measures taken by the states. 8 justices joined in the majority opinion of Justice Bradley, a New Jersey Republican who was a Grant appointee. And only Justice John Marshall Harlan, a Republican from Kentucky, dissented because he pointed out that arguing that the decision robbed the 14th Amendment of most of its power to protect civil rights as the amendment's article intended. Harlan would make another dissent that would have even a more important, that was even more succinct. Now, 2 cases involving segregated railroad cars reflect the court's tacit approval of segregation. In 1878, Hall versus DeCure held that a Louisiana law passed by Louisiana's Reconstruction government that banned segregation in common carriers was unconstitutional because it interfered with interstate commerce. which was reserved to the federal government. Yet in Louisville, in the Louisville and New Orleans and Texas Railroad versus Mississippi, 12 years later in 1890, the court let stand a Mississippi law that required segregated trains engaged in interstate transportation. So on the one hand, requiring integration interfered with interstate commerce, even if it was only within a single state. But in Texas versus Mississippi, a law making the other decision that the cars had to be segregated in intrastate within that state, that this was okay. Now, when white rule was restored in Louisiana, the state flipped and passed a law that required segregated railroad cars. And in Plessy versus Ferguson in 1896, the court upheld the law. An 8-to-1 court held that racial distinctions in the law were not per se discriminatory, and nothing in the 14th Amendment required social as distinguished from political equality. The majority did not use the phrase separate but equal, but that was adopted as the shorthand for its ruling, and it was clearly implied. Now, Justice Harlan, who had dissented from the civil rights cases, all dissented here. He basically said that this is going to ensure that we have race conflict in this country for years to come. And the next, in 1898, in a case called Williams versus Mississippi, the court unanimously held that state laws that were non-discriminatory on their face would not be overturned simply based solely on how they were applied by local officials. The case here was a Mississippi law that said only registered voters could serve on juries, and Mississippi applied its voting laws in such a way with poll taxes and literacy tests that effectively excluded all African Americans from voting. The plaintiff in the case argued that this violated the 14th, that his right to a jury of his peers was violated because the Mississippi practice prevented African Americans from sitting on juries. The court put on blinders to reality and said that so long as the strict reading of the law doesn't contain discriminatory language, how it was applied was not grounds to overturn it under the 14th Amendment. And this kind of reminds me of a song that Tom Lehrer made famous in the 1950s that he called the Ballad of Wernher von Braun. And the lyric was, once the rocket goes up, who cares where it comes down? That's not my department, said Wernher von Braun. So these cases effectively greenlighted mandatory segregation throughout the South. Justice Harlan, as I noted, said that segregation was designed to humiliate citizens of a different race, making racial peace impossible. By the 1890s, legal segregation and discriminatory application of any number of ostensibly racially neutral regulations was the rule in the former slave states, and also several others, including in the Upper South and Midwest, including West Virginia, Oklahoma, and Kansas. Jim Crow was entrenched. And it reached its apogee in the early 20th century when Woodrow Wilson, who had been president of Princeton College and governor of New Jersey, but he was born and raised in Virginia and was a Southerner through and through. And he imposed segregation in federal facilities and federal employment. And a resurgent national KKK became the most popular and largest voluntary association in the United States. And that's where matters stood by the 1920s. And let me stop now and take questions if there are any, because I'm going to change subject. But that's kind of the story from where the end of the Civil War up to the solidification of Jim Crow as the rule throughout much of the United States. Questions?
Well, I'll ask one then. So the case you just talked about sort of reflects the fight between the court right now between this doctrine of originalism. Am I saying that word right?
Yeah.
I mean, was this concept in the court at the time that the argument was whether you interpreted strictly what the words said versus
Not really, because if they did, they would have been forced to acknowledge that they would have forced to acknowledge congressional intent that the 14th Amendment would incorporate the Bill of Rights and make them binding on the states. But the court didn't do that. As a matter of fact, the court never talked about whether the Constitution was a living document or whether it should be interpreted as the words were understood at the time it was written. That wasn't an issue.
Mm-hmm.
That really became an issue starting in the late 1960s and 1970s, and its first accolade was Robert Bork. And it was a response to the Warren Court's expansive reading of the 14th Amendment to, in any number of cases, including Baker versus Carr, which involved reapportionment, that in effect reapportionment of any house in a state legislature other than by population denied voters in more populous counties of equal protection. It was the school prayer cases, the many cases on criminal procedure, from Gideon versus Wainwright to Mapp versus Ohio and Miranda versus Illinois and the exclusionary rule. And so none of these ideas even existed in the minds of people in the late 18th century when the Constitution was written. And this was a way for in my opinion, for conservative / reactionary judges to assert a reading of the Constitution that delegitimatized this type of expansive reading that the Warren Court exemplified. Yes, Ron.
That most contested election that you just talked about, Tilden versus Hayes.
Yeah, 1876.
Right. Can you foresee that we're going to have a mess like that coming up? I know we're all thinking about it.
I hope not for a number of reasons. One is that I think that I'm praying that that there's enough early Biden votes in such numbers that it becomes pretty hard to do that. The other thing is that the court has already held that that electors do not have the right, cannot vote independently of their instructions from the state. If they're selected as an elector, and state law provides that the winner of that election gets the votes in that state, he can't change his mind. So the fact that a Republican state legislature might pick a number of pro-Trump electors, the Supreme Court's already ruled that if under the law of that state, Biden's entitled to the electoral votes, he's got to give them to him. So I'm not sure that that there will be contested electoral college delegations. I don't think that's the issue. In 2000, the issue came down to Florida and which candidate won the popular vote in that state and therefore was entitled to those electors. And the state was decided by less than 500 votes. And then the Supreme Court intervened and said, stop the count. In an opinion that they acknowledged would not be used as precedent in any other case. So it was blatantly political. It was probably, in my opinion, one of the worst decisions the court ever made. There was nothing that said that the court could not allow the count to go forward. They had enough time to do it. Interestingly enough, and this is getting ahead to next week, the lawyers on the opposite sides of that case were co-counsel in the case to support gay marriage in California. Mm-hmm. Ted Olson and Bill Gaines. So I'll get to that next week. Any other questions? Okay, let me go on. We got a little bit more before the break. The NAACP was founded in 1908. It established a legal defense and education fund. Thurgood Marshall joined it in 1936 and became its head in 1940. Marshall understood that segregation could never be equal as it imposed a badge of servitude, and those were his words, on the discriminated minority. And he saw two approaches to challenge Jim Crow. One was fairly simple. It challenged segregated facilities as being overtly unequal based on the amount of money and other resources that were provided for the state or local government to the white and black facilities. That was one approach. The second approach was to try and overturn Williams versus Mississippi and have the courts look at how laws were applied, not just whether they were discriminatory on their face. And believe it or not, there was a 1988 case, Wick-Yo, W-I-C-K-Y-O versus Hopkins, to support him. That case overturned a San Francisco ordinance that was designed to put Chinese laundries out of business. And the court threw it out because it said that laws that public officials applied to minorities, quote, with an evil eye and an unequal hand, close quote, violated the Constitution. Now, Wick-Yo had been cited in any number of cases that had supported segregation in the South. But Marshall hoped that changes to the court and changes in attitudes might give that case more legs. By the way, there is a wonderful film available of a play that Lawrence Fishburne starred in called Thurgood, which was a one-person play on the life of Thurgood Marshall with Fishburne playing Marshall. It was a play that toured the country. I saw it in Los Angeles, and it was one of the most powerful things I'd ever seen. When it appeared in Washington, D.C., HBO filmed it, and it showed on HBO. I searched, and the only place it's available now to stream is you can either get the disc from your local library. I have a copy of it. Or you can see it on Amazon if you're willing to pay $3.99. It's available to stream on Amazon for $4. And I highly recommend it. It's called Thurgood. And if you have Amazon Prime or, it's available to stream, I highly, highly recommend it. Marshall understood that in the 1930s and 40s, the country, especially, yeah, I'm sorry?
Sorry.
I think, Barry,
Yeah.
would you mute everybody but me, and then I'll unmute myself?
I think, okay, that everybody else is muted now.
So I'm unmuted, okay.
You're okay.
Okay. Marshall understood that white politicians in the South would never vote to raise the millions of dollars needed to bring black schools up to par with white schools. However, he did see an opening in the border states to attack the lack of graduate opportunities for African Americans. And in 1938, in a case called Gaines versus Canada, Marshall successfully argued that Missouri could not admit whites to the state's only public law school while denying admissions to blacks. On remand, Missouri quickly opened a separate school, school for African American, separate law school for African American lawyers. World War II and the Cold War had transformative impacts. African American soldiers who fought for freedom in Europe and had experienced the more open societies in England and France were struck by the incongruities presented by American racial attitudes and the legal subjugation of blacks in the South. And American race relations became a burning issue in the post-Civil War competition between the United States and the Soviet Union. Remember, post-World War II saw the effective end of the French and British empires. And most of the new countries that gained independence in these years were essentially non-white, had non-white populations. And while as third world countries gained independence, the Soviet Union appealed for their allegiance, pointing out the injustice of American racial laws and practices. The Cold War revealed an incongruity in how officials viewed civil rights, agitation. The State Department and the National Security Establishment argued that racial segregation played into Soviet propaganda and arguments for Third World Alliance. But local officials throughout the South and any number of law enforcement agencies across America, including the FBI, viewed civil rights agitation as Soviet-inspired attacks on the American way of life. Many of us remember that the FBI and other agencies attacked Martin Luther King, Malcolm X, Angela Davis, the Black Panthers, etc., and all of which were trying to attack movements that were in support of civil rights. So this is the situation in the late 1940s. And in the face of post-war housing shortages, the NAACP tried to attack the restrictive covenants that preserved most urban and all suburban housing to whites only, and often only to white Christians. What it was provisions were placed in deeds that stated that this property shall not be sold, that the parties between the grantor and the grantee agreed that from this point forward, this property shall not be occupied by any person other than a Caucasian, and often only other than a Caucasian Christian. That's called a restrictive covenant. A 1926 case, Corrigan versus Black, had held that such provisions and deeds were private contracts and weren't subject to constitutional scrutiny, and enforcing them did not constitute state action. That was a 1926 case. But after the war, the NAACP and Marshall saw an opportunity to change the outcome. And they took a case, Shelley versus Kramer, to the Supreme Court for its 1947-1948 term. And this was when the emerging Cold War dominated US foreign and military policy. When this case was briefed, the United States State Department filed an amicus brief. Under seal meant that it was only for the judge's eyes. And for the first time, and it argued that enforcing restrictive covenants, that this type of segregation was a threat to national security because it played into Soviet propaganda, and therefore it's against America's national security interest. For the first time since Reconstruction, the US government officially opposed segregation. And this was monumental. Now, what did the court do? Well, it did something very interesting. The court decision was unanimous. It acknowledged that this is a private contract between the grantor and the grantee. That's how it came up. And the Constitution does not speak to tell people what they can and cannot put in their contracts. But enforcing it, that's a different issue. So even though it's there, if it were to be enforced, and the way to enforce it is by, of course, enforcing punishing its disobedience, that if state courts or local, if any court were to enforce it or grant a judgment or allow a lawsuit to proceed based on it, that would constitute state action in violation of the 14th Amendment. When the decision came down, Voice of America broadcast celebrated the decision the same day it was announced. Then Marshall persuaded the court to accept two cases that attacked segregated graduate education. In Sweat versus Painter, S-W-E-A-T-T, the court unanimously held that Texas's one state black law school, which consisted of 2 rooms in the basement, in a building's basement with 3 teachers and no libraries, was unequal as a matter of law compared to the whites-only public law school at the University of Texas. And in McLaren versus Oklahoma, the court also unanimously held that unequal treatment of a black law student that required him to sit apart from where whites couldn't see him and restricted his use of the library and cafeteria was improper, and all students at the school must be treated equally. And concurrently with those two cases, the NAACP mounted a frontal attack on school segregation. A number of cases were filed in 4 states and in Washington, D.C., and several went to trial. Thurgood Marshall handled the trial in South Carolina. In 1952, the court, then led by Chief Justice Fred Vinson, announced that it would hear the cases consolidated as Brown versus Board of Education of Topeka, Kansas, so it would not appear to be only against the South. And I think this is a good time to take a break before we get to the case itself, but that's where we are up to the Supreme Court taking Brown versus Board of Education. Any further questions before we take a break?
I just have one procedure. You're reading from something. Is this a book or is this a script?
No, this is 22 pages of stuff that I put together because it was too much to memorize, and this is what I've been writing for the last 3 days.
Well, I'd appreciate it if you could release that, because you're going through a tremendous amount of detail. It's impossible for an old guy like me to pick it up.
I would have to spend another tremendous amount of time revising it, because about a third of the time I'm rephrasing stuff. I'm changing it as I go along. This is the way I lectured when I was in college. I would walk around a classroom holding the sheaf of papers in my hand, sometimes referring to it and sometimes not, because I wanted to make sure I stayed on message. Lecturers have a tendency to kind of let their mouth go where their mind may take them. And that makes it really hard for students to take notes and follow a lecture. And I knew that from experience. So I've always kind of talked from, you would think of a script, but there's so many abbreviations in this and so many changes in so many places where I've deviated from it that I'm really not in position to send it out. I apologize for that. So now we're talking about Brown. And although Brown was the lead plaintiff's counsel was Thurgood Marshall, and he decided to frame his argument on the evidence, based on the evidence that he had presented at trial in the South Carolina case. Now, he followed a practice that was initiated in the early 1900s by Louis Brandeis in child labor cases. And that was to fill the trial record with factual evidence of the harm that would be caused by either the present law continuing or failure to file whatever changes being sought. So Marshall's brief before the Supreme Court incorporated extensive trial evidence from psychologists and other experts on segregation's pervasive and pernicious impact on Black and white students. Such evidence included test results indicating that Black children of equal learning ability did more poorly due to feelings of inferiority engendered by attending schools with inferior, poorly paid teachers in rundown settings that were common to Black-only schools. And psychologists explained why young Black kids offered white and Black dolls to play with tended to prefer to play with the white ones, which they associated with goodness. Now, when the case came before the court in early 1953, the case consumed 3 days of, in late 1952, December 1952, it consumed 3 days of arguments. Now, that's an indulgence that's rarely followed these days. Now usually sides get a half an hour apiece or maybe 30, 45 minutes apiece at the most to talk. The plaintiff's arguments can be boiled down to one main idea. Segregated public education was inherently unequal due to its pernicious effect of branding the minority race as inferior. And for that reason, it violated the equal protection mandate of the 14th Amendment. Now, the defendants, representing the southern states and the segregated school districts, stressed 4 main points. First, public education was always, in this country, had been a local issue, not a federal issue. And it's an issue that must be assessed locally where the people lived because it was so close to them. Secondly, they argued that Plessy's separate but equal doctrine was good law and had been held as many as 7 times over the past 50 years. Third, they argued and showed that the states were making a good faith effort to put more money and resources into Black-only schools to make them more equal. And lastly, they argued that the court should not make orders which were both unnecessary and contrary to deeply ingrained cultural realities of life in the local areas. Now, there's no formal record of what happens behind the closed doors in the justices' regular Friday morning conferences. Every Friday morning, the judges gather to discuss the cases that were argued that week. No one is allowed in the room but the justices. They always every justice shakes every other's hand before they start. And the junior justice has the duty of going to the door to ask for coffee or to ask that any documents be brought in or to take any messages. But no one's ever allowed to come in. But fortunately, we have memorandums that William O. Douglas left in his papers that after oral argument, the court was sharply divided. Then Chief Justice Fred Vinson, along with Justices Reed, Frankfurter, Jackson, and Clark, preferred to uphold Plessy, while the other 4, Justices Black, Douglas, Burton, and Minton, argued that the time had come to end mandatory segregation in public schools. Now, remember, this was in December, barely a month after Eisenhower and the Republican Party had swept that year's general elections. Now, before the justices took a formal vote in their conference, Justice Frankfurter suggested that the case be reset for further argument on 5 specific questions. And on 5 specific questions, and that the court invite the incoming Eisenhower administration to, which would take office in January, to file a brief with the federal government's position. And it was the fact that the government was changing hands, that Republicans were had the majority and were taking over the executive branch. And Frankfurter felt that this newest administration should have its opportunity to address the court on this issue before they decided the case. Now, at heart, I think Frankfurter might have wanted to avoid a 5-4 decision. I think he wanted to avoid having to take a stand, to uphold Plessy, which he felt was appropriate because he put a huge emphasis in judicial restraint. Frankfurter's belief was that justices should give preference to precedents, that precedents should not be overruled except for in the direst emergencies, and that it certainly should not happen on a close vote. Now, the 5 points that the case invited for re-argument are telling. They tell you where the justices were coming from. First, they wanted evidence. They wanted to know what was the intention of the 14th Amendment with regard to public education. Secondly, if not, was it ever contemplated that a future Congress might abolish segregation based on the 14th Amendment? Now, even if Congress hadn't contemplated that, was it in the court's power to do so? And if it was, should it take effect immediately over a period of time? And if it's going to happen over a period of time, how would it be enforced? Would there be a special master appointed by the court? Would the Department of Justice have to take control of it? Or would the lower federal courts do it? This was a real issue because whenever you make an order that something has to be done in the future, the order only makes sense as if there's some way. How do you determine if in fact that's happening? Who has the power to say, yes, this is sufficient, or no, this isn't? And so these are the 5 questions that had to be decided. Frankfurter's suggestion was approved unanimously. All 9 of them realized that the issue was too big to be resolved by a closely divided court. And all 9 of them were eager to push the cart down the road. Now, Eisenhower the new president, was torn. He was committed to ending racial segregation wherever the federal government had direct control. He approved of Truman's decision to desegregate the military. He believed that the federal bureaucracy must be desegregated, that all federal facilities and military installations should be desegregated. But Eisenhower had been raised in segregated Kansas, and he believed that racial segregation was so deeply embedded in a large swath of American life that finding it unconstitutional would set the federal government against Southern political and social culture. He once expressed this in racist terms, quote, "White parents are not prepared to have their daughters attend schools surrounded by young black bucks," close quote. And that's, and this was Eisenhower talking off the record. And quite frankly, in the 1950s, that was a common language. Now, Eisenhower's chief political domestic advisor was his Attorney General, Herbert Brownell. Brownell was the leader of the Eisenhower forces in the convention that got Eisenhower the nomination. And he was literally the head of Eisenhower's, he was the chief advisor on domestic policy. Brownell told Ike that he believed that Plessy should be overruled. And Eisenhower supposedly told Brownell, if that's what you believe, then say so. The government then filed a brief arguing that Plessy should be overruled, that the Supreme Court had the power to end legally required segregation in public schools, and that the 14th Amendment established a broad constitutional requirement of complete equality under law. And that also America's interest in foreign policy and national security would be served by such a ruling. Eisenhower would later tell Southern governors that I don't control Brownell. The governor's brief only spoke to legal issues, and it wasn't political, as if nothing's not political. Now, there's a myth during the 1952 GOP convention that Eisenhower forces offered Earl Warren the first Supreme Court vacancy that would come up if Warren would agree not to run for president and endorse Eisenhower on the first ballot. Many of us in California grew up with that understanding. Well, let me tell you something, didn't happen. It's a myth. Warren's delegates voted for Warren nonetheless, and Eisenhower still won the nomination on the first ballot, and Warren never endorsed Eisenhower until after he had the nomination. Now, after Ike took office, Warren had decided he didn't want to run for a third term as California's governor. And he approached Brownell and said, hey, is there anything for me in your administration? And Brownell said, yeah, how would you like to be named the Solicitor General? Now, the Solicitor General is the official who officially represents the federal government in arguments before the US Supreme Court. Elena Kagan had been Solicitor General before Barack Obama put her on the court. And Robert Bork had been Solicitor General when Nixon had nominated him. He didn't get the gig, but that's where he was. It's a fairly important position. And Warren took it. He agreed to that job, and actually in August of 1953, he started preparing for arguments in the cases that he knew would be set on the court's docket in October. But before Warren started in his new job, Fred Vinson died on September 8th, 1953, and Ike had to name a new Chief Justice. Eisenhower told Brownell that Eisenhower would rather appoint a moderate with political experience rather than a legal scholar or an existing appellate judge. And Brownell said, well, what about Warren? And Ike decided to give him the job on Brownell's recommendation. Warren was sworn in on October 5th, and when the Supreme Court's term began. Now, Warren wasn't a legal scholar, but he had rock solid political instincts. He asked the senior justice, Hugo Black, to chair the first month's conferences until Warren felt comfortable in the gig. Black was then the judge with the most seniority. And he also quickly cultivated Felix Frankfurter's advice on constitutionalism issues. Now, there's two reasons to doing so. One, it was pretty much acknowledged at that time that Frankfurter, who had come out of Harvard Law School, was probably one of the most accomplished constitutional scholars on or off the court. And secondly, Warren also quickly figured out that Felix Frankfurter not only knew that he was smart, he knew he was smart, and he had an ego to match his legal, that went just as big as the quality of his legal mind. So now Brown comes up for re-argument in December 1953. Warren has been on the court now for 2.5 months, and by all reports, Marshall's arguments were much more ably presented than had been the case a year previously. And Thurgood Marshall admits this. What's one of the points that is made in the play and in his writings. Can I tell you guys a story about Thurgood Marshall that I think is absolutely wonderful? You know, Lyndon Johnson put him on the Supreme Court. He was the first African-American on the Supreme Court. And he was clearly aligned with what we call the Warren wing, an expansive view of the Constitution's obligations to protect and expand minority rights. And Nixon did not like this. Now, while he was on the court during the Nixon administration, Marshall came down with a case of pneumonia and was pretty sick, and he was admitted to Walter Reed Hospital. Nixon called the hospital and asked to see copies of Marshall's medical records. So the hospital went to Marshall and said, the president would like to see your medical records. Is that okay? Marshall said, okay, on one condition, bring them to me first. So they bring him the records, you know, this is before email. So they bring him a copy of the records, and he takes a felt tip pen and writes on the first page, not yet, goddammit. No, I think that I just love that. That's my favorite Thurgood Marshall story. Okay. Robert Jackson, we're getting back. So Marshall's arguments were more ably presented than in the first time. And he felt that the court seemed more receptive. Justice Robert Jackson, by the way, who had taken leave from the court to serve as lead prosecutor in the 1946 Nuremberg war crimes trial, along with Frankfurter, challenged Marshall's argument that Plessy had been weakened by recent cases. The defendants again stressed that Plessy was good law, that public education should be left to local control, and that Southern states were in the process of raising money to invest in Black schools, thus making good faith efforts to make them more equal. And there were appeals and argument to emotions. The lawyer for the states was a guy named Davis, who had argued at the time more cases before the Supreme Court than any other lawyer in American history. And he kind of made this argument like almost a Daniel Webster plea, that this is my last cases before the court, and I honestly believe you justices should uphold, you know, the rights of our constituents. Now, as I mentioned, the Friday morning conferences are confidential, and nobody's allowed the room except the justices themselves. But fortunately, we have Douglas's memos and Warren's writings to tell us what happened. And Warren opened the discussion by insisting that all the discussions be informal and that no formal votes be taken until a consensus appeared. But Warren did state that the court could not avoid deciding whether or not to overrule Plessy. And he did state that in his view, to sustain Plessy perpetuated an underlying assumption that Blacks were inferior to whites. He indicated that there were 5 firm votes to rule for the plaintiffs, yet he acknowledged that the court should not take precipitous action and that a 5-4 opinion would maximize and encourage opposition and turmoil. When discussion, after Warren made his opening remarks, discussion opened. And Justice Reed from Kentucky agreed that Blacks were not inferior, but he didn't want to overturn a precedent that enjoyed such long-standing support. but he conceded that what was constitutional in the 1890s might not be the case now. Texan Tom Clark said that he now better understood the racial problem and would agree to overrule Plessy if it could be done carefully so as to not do more harm than good. Justice Jackson, who again was conservative at heart when it came to precedents, believed that Plessy was good law, but he would not join in the court's opinion, but he would go along with the result because of the need to counter Soviet propaganda. And Justice Frankfurter, he vowed that before he was on the court, he always advanced racial justice as a political question. But as a judge, he believed in judicial restraint, where political questions should be decided by political institutions and not the court, as if the court isn't political. That's me talking. In the ensuing days, Warren had numerous informal one-on-one discussions with his fellow justices. Warren stressed that on such a momentous matter, the court must speak with one voice. Frankfurter agreed, provided the country was given time to adjust. Jackson presented a problem. He hated Hugo Black. He believed that Black had persuaded Truman to appoint Vincent as Chief Justice rather than him. And let me tell you, when you have a group of 9 people and some of them don't talk to each other, it's like having a roommate that you're not talking to, or what happens when parents are about to get a divorce. I mean, this was not pretty. Jackson did not agree that constitutional questions should be decided based on subjective psychological factors, but he agreed to go along for the national security reasons. But he indicated that he might be persuaded not to write separately. Reed wanted to hold out that Plessy should not be overruled, although he acknowledged that segregated schools were unequal in every instance where financial and physical resources were unequal. He wanted to rule for the plaintiffs, but not on the main questions. He wanted to find that all the schools in question were unequal unless on a dollar-for-dollar basis and teacher-for-teacher basis that all money spent and resources available and qualifications were equal. In March 1954, which was about two and a half months before the term was to come to an end, Warren called for a vote, and it was 8-1. Reed was the only negative vote. Warren assigned writing the opinion to himself, and he promised the other justices that it would not be phrased as an indictment of Southern culture. He said that the language would be clear and readily understandable, and that to overrule Plessy opened a new and critical chapter in American race relations. He also agreed that how to implement any decision was so complex that it should be set for argument the following term, and the court should not have to decide that question at this time. In his memoirs, there's an interesting story to tell. Warren recounts that while drafts of the opinion were in circulation, he decided to take a weekend visit to visit the Civil War battlefields around Washington, D.C. Remember, Warren was a Californian. Believe it or not, up until this time, he had never been to Washington, not in years, and he'd never visited any of the Civil War battlefields. So he had his driver take him to explore the Gettysburg in southern Pennsylvania, Antietam in Maryland, and Manassas, and the Manassas battlefield in Northern Virginia. And he spent the night in a Virginian country inn. When he got up the next morning, he saw that his driver had slept in the car. And he asked him, why? And the driver responded, well, Mr. Justice, I just couldn't find a place where I can stay. And Warren says this really brought it home to him, what the effect of segregation was. Warren then took the opinion to Justice Reed, the one holdout, and asked Reed if he truly believed that a lone dissent would be good for the country. Reed was a Southerner and realized that his dissent from the majority, even if he concurred in the result but didn't adopt the same reasoning, would increase Southern resistance. Reed agreed not to dissent and to join the opinion as long as the South would be given time to work out gradual implementation. Justice Jackson recently had a severe heart attack, and he would die a matter of months after the opinion was denounced, agreed to join in Warren's opinion, not write separately, and just join to make it unanimous. A year earlier, a hopelessly divided court was prepared to uphold Plessy and school segregation on a 5-4 vote. Earl Warren, who had never been a judge, had limited courtroom experience, he'd been the district attorney of Alameda County, used his consummate political skills to construct a unanimous decision to outlaw mandatory school segregation and start a process that began and continues to revolutionize race relations. The decision was announced on May 17, 1954, with all 9 justices present. Justice Jackson left his hospital bed to attend. Warren read the opinion from the bench. Justice Reed recalled that he cried as the Warren was reading. Frankfurter told Warren, quote, "This is a day which will live in glory." And within hours, the Voice of America broadcast news of the decision in 35 languages. Now, Warren's opinion was a masterful document. It was short. It's barely 11 pages long. It acknowledged that nothing in the history of the 14th Amendment's adoption supported overruling Plessy. But looking at both tangible and intangible factors, Warren wrote that enforced segregation in public education was inherently unequal and therefore constituted state action that deprived minority children of the equal protection of the laws, that it was both contrary to the letter and the spirit of the 14th Amendment. I urge you all to Google it. I think it's one of the great state papers in American history. It doesn't have the same rhetorical magnificence of Lincoln's Gettysburg Address or a second inaugural, of JFK's For Freedom speech or Kennedy's inaugural address or his 1963 address on civil rights. But it has an eloquent directness to be envied and admired. And here's, I put this slide up because I think it's important to see how he reduced this terribly complex issue to one of fundamental fairness that it was really hard not to, to take issue with. And I think there's a certain elegance to it. And yes, I do get kind of emotional about this stuff. When the parties returned to address enforcement in what became known as Brown II, the government's brief suggested that federal district courts should have the primary duty to enforce how and when the decision should be implemented in each district, and to do so as quickly as feasible. Note, the government didn't say to do so as quickly as possible, but to do as quickly as feasible. Thurgood Marshall argued that a right is a right, and all public schools should be required to fully desegregate no later than September 1956. On the other side, Southern states defiantly demanded respect for state sovereignty, that the court not order any compliance that would lead to massive resistance. In conference, all 9 justices agreed that enforcement should be supervised by the district courts. Let each district court judge who's on the scene, rather than by some central authority, be it the federal government itself, the Department of Justice, or a special master, make the decisions. That the decisions should be made locally, and they should be subject to normal appellate review, which is what happened. And they agreed that the district courts should have maximum flexibility to accommodate good faith efforts by local officials, but while reinforcing the moral imperative of the decision, and that out and out resistance should not be permitted. And again, Warren was able to get his 8 fellow justices to agree in an opinion that acknowledged the complexity of integrated public schools after 70 years of entrenched segregation, but nonetheless stated the court expected compliance, quote, with all deliberate speed, close quote. I think that most of us are of an age to remember that Southern resistance was fierce and often effective. Southern op-ed pages castigated Brown as worse than Dred Scott. Southern legislatures refused to vote bond issues. School boards refused to spend money to integrate and even voted to dissolve themselves as privately segregated academies siphoned off white students where integration was implemented. In 1956, over 100 senators and representatives from the former slave states signed a Southern Manifesto, that's what it was called, declaring lifelong defiance to integration and a commitment to end public education rather than comply. The only Southern senators who refused to sign it were Lyndon Johnson, Estes Kefauver, who had been Adlai Stevenson's running mate, and Al Gore Sr., Al Gore Jr.'s father. Eisenhower tried to have it both ways. He gave lip service to the need to obey the law, and all of his judicial appointments actively supported Brown. Yet I did not support civil rights enforcement and said that integrating schools, quote, scared people to death, close quote. But in September 1957, rioting in Little Rock, Arkansas over a district court order to integrate that city's Central High School forced Eisenhower's hand. It was his worst nightmare. Horrible displays of white racism that played into Soviet propaganda and outright defiance of federal authority by state officials from Governor Oral Faubus on down. And ultimately, Eisenhower was compelled to nationalize the Arkansas National Guard to surround the school, keep invective yelling whites at bay, and allow the enrollment of a few Black students. And we saw, after that, what was it? There was Ross Burnett resisting Governor Ross Burnett of Mississippi, interfering with the federal government's attempt to enforce an order requiring integration of the University of Mississippi. And of course, George Wallace's famous standing at the quote schoolhouse door at the University of Alabama saying segregation now and segregation forever. Eisenhower's decision to use the National Guard to enforce the order to integrate Central High was the first time since Reconstruction that federal power was used to compel equal treatment of African Americans by hostile local officials. Over the next 13 years, it wouldn't be the last. Eisenhower was angry. He refused to meet with Martin Luther King or Roy Wilkins, who was then president of the NAACP. And he grew to deeply resent both Warren and the court's rulings on race in any number of subjects. And he later said that appointing Earl Warren Chief Justice was, quote, the worst damn mistake I ever made, close quote. Okay, that's my take on Brown versus Board of Education. I could talk a lot more on what happened after Brown, post-Brown. The whole problem, Brown opened a whole door to issues of affirmative action, of set-asides, of quotas, of how do you undo this? How do you deal with, and what's the proper way to not only atone, but also to ameliorate the impacts that voluntary segregation had over so many years. I mean, this touches on the whole civil rights dispute. Don't have time to do that. So that's where we are. And I guess the floor is open to question and comments.
Okay, great. Great.
Arthur.
Yes.
Ron again. In short, do you think that Brown will ever be overturned?
No. Do I think that segregation will ever be reinstated? No, I don't.
Well, that's one good thing.
Well, but Brown has never been fully enforced either, has it?
Well, yeah, in a way it has. Look, the state government, yes, it did cause white flight throughout both North and the South. It developed a tremendous increase in private school education, such that many of our school districts in our southern cities are minority majority school districts. but it did have a tremendous effect. If Brown had not been decided the way it was, do you really think Congress would have ever passed the '64 Civil Rights Act that ended segregation in all public accommodations? Do you think Congress would ever have passed the 1965 Voting Rights Act? Brown.
What about the fact that the Voting Rights Act has been pulled back?
Well, that's another whole issue.
Did they pull
I mean,
back
that's just, to me, that's bad law. Look, the story in that case is that Justice Roberts, speaking for a 5-4 majority, held that Congress's decision to require pre-clearance, notwithstanding Congress's statement that there was a factual basis for doing so, exceeded Congress's power. That there wasn't a sufficient factual basis to require pre-clearance. Even though a year earlier, Roberts had said that even though we think the ACA's mandatory health insurance provisions are both bad policy and bad law, we're not going to overrule it because that's Congress's decision. There's a total incongruity. There's no other way to explain it then. It's a blatantly political decision that Roberts and the majority of the court decided that they didn't like the idea of pre-clearance because it hurt Republicans. I mean, pardon me, but any version of him that he was merely, quote, calling it like a referee is total BS.
So you don't think he did that with Brown versus Board?
No, I don't think he would. I don't think he would. I think Justice Roberts is, and even some of the other conservative judges are institutionalists. This fly is getting to me. That's the first good use of the Constitution that has ever been used for. This would be too big a revolt. They couldn't do it.
Well, my question, Arthur, is you talked about Thurgood Marshall's presentation before the court. To what extent do these short, actual in-person presentations have a big influence? Because the case, I assume, is also pages and pages of written argument. Is that true? So to what extent?
Yes, that's true. It is pages and pages of written argument, and frequently judges have already expressed opinions when a case is decided for the court. They frequently have formed opinions. I mean, I used to argue cases before the California Court of Appeal, and it always amazed me that I'd argue a case on Thursday and the decision would be on my desk on Monday, sometimes on Friday. So I think that, but on the other hand, I think that for a judge who's undecided, and frequently there are judges who are undecided. It's infamous that Harry Blackmun couldn't make. He was like the person who could never make up his mind about anything. He would always say, "Well, on the other hand," and people were always amazed how he ever signed or wrote a decision. He was kind of, in that sense, he had a reputation for being wishy-washy. And for a judge who is really on the edge, frequently the judge might ask a question and then the lawyer's response to that question will crystallize in his mind the proper point of view, or another judge will do so. But frequently also it's well understood that judges' questions often are designed more for the judge to express his opinion than and to try and persuade other justices because they're loaded questions. I mean, that's part of advocacy.
Justices also will use the opportunity for oral argument to raise a red herring. And throw the counsel off their game.
They will do that.
I observed that in person on a case that I had.
Did you argue before the Supreme Court?
I lost. I had the case with co-counsel. We flipped a coin. I lost. I argued and won before the 3-judge district court panel. My colleague argued and lost before the Supreme Court. But what happened in oral argument was Justice Rehnquist, who at that time was Chief Justice, raised an issue that neither side had raised or briefed, and essentially took up a fair amount of the time allotted for argument, kind of playing games with my co-counsel.
Well, you have experience that I don't have. I've argued before the California Court of Appeal, but I was not an appellate lawyer, so I never had that experience. Maybe have I said anything that was wrong?
Not that I heard. Now I had to leave for part of your presentation, so I didn't hear it all. But based on what I heard, I'll assume that it was all right.
Well, thank you.
No.